Now, let me introduce our next session, Separation of Church and State in 2021, with our legal director and senior counsel, Monica Miller, and our paralegal, Isabel Oldfield.
Thanks so much, Nicole. My name's Izzy, and my pronouns are she, her. As Nicole mentioned, I am a support staffer within our legal center, and I will be asking Monica a few questions so that we can talk about our current caseload and some of the upcoming cases of note as well. Monica?
Hello, thank you all for joining us. I see we've got a lot of participants. Welcome, and I'm excited to talk all things separation of church and state today here with Izzy, and look forward to taking a few questions at the end.
Great. So to start us off, can you talk about any of our highlights from the last year, any victories maybe?
Yeah, so despite having a very lousy year as far as public health goes, as far as what was going on in DC right up until the election. We had an insurrection, we had the very tragic loss of Ruth Bader Ginsburg. So it's been a really rough year since our last conference. But that being said, we've seen some legal victories. We've had some legal victories. We've also seen some Supreme Court cases that we expected to be absolutely horrendous, that weren't as bad as they potentially could have been, but we have a lot of concerns and a lot of work to do going forward. But I will start us off with one of our biggest legal victories to date, since we really started bringing these cases about 10 years ago, is our case against the Greenville County School District over graduation prayer. And you've probably heard me talk about this case more than once, since it has been going on for basically forever. It was about our longest case, I think 8 years from start to finish. We went up to the Fourth Circuit Court of Appeals thrice, won all of our appeals. We ended up at the beginning of this case getting actually a different district court judge on remand, because we found the higher court found our judge to be discriminatory towards us. But ultimately, we closed this long-standing and very big and public case with a win, which held that the Greenville County School District, one of the largest school districts in South Carolina, can no longer have school-sponsored graduation prayers, and they can no longer have they can no longer be holding graduation ceremonies in religious venues, such as Christian chapels and Christian universities that have sectarian symbols all over the place, which is what they had been doing. So, this was just a major victory, in part, not only because we won the legal issues that for the most part, almost all of the legal issues we set out to win about a decade ago, but also because my other motive was to keep this case, whether student-led prayers at graduation ceremonies, getting that case out of the Supreme Court's hands. If we had been in the Fourth Circuit Court of Appeals, which is where the case was at the time we ended up winning, and if we won, the other side could have taken this school prayer case to this now 6-3 conservative Supreme Court with Judge Barrett and Gorsuch, and it would have not gone well. So we not only dodged a very serious Supreme Court bullet in which student-led prayer could have been upheld, but we also actually won the case. So I'm really excited to sort of kick us off today with starting with that win, because we're really proud of it, and it's just nice to see a case end favorably during a climate like this.
Great. And then another one that was kind of an unusual, activity for us, but maybe you can go into depth about it, is the Uzigbunam versus Przewski case, in which we actually supported the Alliance Defending Freedom. So can you explain that?
Sure. So this is an interesting case. So the Alliance Defending Freedom is one of our typical opponents, if anyone's familiar with them. They are in the same camp with Federalist Society, Becket Fund, ACLJ, just kind of the whole religious conservative conglomerate. They had a case in the 11th Circuit Court of Appeals. There's all the circuit courts that feed up to the Supreme Court. And the 11th Circuit Court of Appeals is probably the most conservative of the circuits. And we have a case pending there involving the Ocala Police Department. We won a case against them, holding that the Ocala Police Department and the city violated the separation of church and state by staging a very government-organized, government-sponsored prayer vigil. And so we won this case, and then it went up to appeal on the 11th Circuit. And during the time it was pending appeal, the Alliance Defending Freedom also had a case pending in the 11th Circuit, and they lost it. The problem is they lost on the same grounds that we had that we had won on, in the sense of the remedy, nominal damages. So when we bring a civil rights case, we don't go usually after pocketbooks, because there's no financial loss usually when you violate the Establishment Clause. I see a cross, nothing comes out of my pocketbook. It's a symbolic injury. So the problem in these symbolic injury cases is that the government can change course. They could take away a monument, they can change a policy. And so you no longer can just sue to stop the activity. All you have left is the violation you've already suffered. And because there's no loss of money, you only have what's known as nominal damages. And it's the law's way of compensating you for a loss of a constitutional violation. And it's $1, but it's a symbolic remedy that says your rights were violated. It holds the city accountable, or the government accountable, by saying you violated the law. It continues a case forward. So nominal damages are vital to our cases, so that they don't get mooted out. Anyways, the 11th Circuit Court of Appeals held in the Alliance Defending Freedom case that the remedy of nominal damages for a constitutional violation it doesn't exist when there's no remaining claims for forward-looking relief. So if the government stops the practice and your rights have already been violated and there's no money loss, they kind of said tough luck. And not only did this concern me for the standpoint of our police prayer vigil case, which it did, but from a very, very fundamental standpoint of as a lawyer and as someone that cares about the rule of law, the notion that the government can violate your rights, blatantly or otherwise, in a one-time situation and get away with it, with impunity, is horrendous. And especially during a time, this ruling came down at a time when there was an insurrection, and we had a president disavowing science and saying all sorts of incredible things on the internet. And so, you're just shaking your head, like, you're going to give the government the green light to violate people's rights as long as they do it once and change it, or just do it once, period, and just keep doing one-off violations as long as they're creative enough and don't have, so the bottom line is we reach out to Alliance Defending Freedom, our enemies, normally enemies. And it was like this low profile case, no one's paying attention. And I was like, do you guys want our help, an unlikely bedfellow, to get this case in front of the Supreme Court? And they said, do you think we should even bring it to the Supreme Court? They were just going to let it lie. I mean, I don't know if they really were, but they weren't really sure. And so we talked about it. And ultimately, we filed a brief at the cert stage. So to say, Supreme Court, please take this case and overrule it. And what a better person to take it to the Supreme Court group than a religious group that the Supreme Court would favor. So it worked out really well. They were super grateful for our help. We filed it both at the cert stage, the Supreme Court took it, and then at the merit stage. And we had a lot of, we reached out to some of the other groups, but they had an understandable didn't want to get involved with siding with Alliance Defending Freedom. And that's totally understandable. We made it really clear in our brief, the only reason why we're siding with them isn't because of them, it's because of this remedy that transcends all of what our groups do. So ultimately we got a win. The Supreme Court reversed the decision. Now it's very clear. So it's not just like they reversed the decision, but now we have a very clear Supreme Court ruling that nominal damage remedy is available if no other remedy is available or otherwise for a constitutional violation. So it's great. It's a great win. It doesn't have to do directly with church-state separation, but in a lot of ways, it has everything to do with it, because without that remedy, we would lose the power to bring most of the many cases we would otherwise bring.
Yes, and also just to reinforce that, I thought it was super interesting too, because, when you're explaining that we sort of supported Alliance Defending Freedom at the Supreme Court, it's interesting to see that our ability to sometimes bring Establishment Clause cases or to protect civil rights comes down to something like nominal damages, or just the importance of having those different types of standing and remedy supported at the Supreme Court so that we can all keep doing the same work. And obviously we're at different ends of the spectrum in terms of what we're trying to do for civil rights, the American Humanist Association and the Alliance Defending Freedom. But at the core, we still rely on those same legal tendrils in order to get ourselves before the Supreme Court or federal court in general. So moving into, sorry, go ahead.
Oh yeah, I was just going to say, if I may add also, this whole experience of befriending our enemies in a way. I mean, and honestly, when we work in our cases, I'm usually diplomatic with opposing counsel. I tend to actually have quite a good relationship with them. In fact, the South Carolina case, that, the 8-year case, you would think me and opposing counsel would just absolutely hate each other, but we've actually become friends. He's a lawyer in South Carolina, and we still touch base. I mean, we really, we work together on this case, even though he's on the other side. With Alliance Defending Freedom, because they're linked in with, Federalist Society and this and that, we're going to be against these people forever. I mean, as long as I'm in this career, these groups are my opponents. And so, having a friendly relationship with them is very, it can end up opening some doors for us in the secular community as far as getting a seat at the table. And a perfect example of that is I was actually invited by the Yale Federalist Society, because of our amicus brief in this case, to come out and speak about the case to the Yale Federalist Society with the woman that argued the case for ADF. So it's that gives us a way to now reach another audience and potentially explain to them our how separation of church and state benefits religion in many ways more than it benefits atheism. I gave a talk to the Catholic school, a middle school Catholic school this past sometime between now and our last meeting, and the Catholic school teachers totally agreed with what we were doing, because I kind of framed it in a way that wasn't misleading, just it's what we're doing. And the message gets so garbled by Fox News and other spokespeople about what separation of church and state is, a war on religion, a war on Christmas. And it's like, no, we're protecting the sanctity of your religion from government intrusion. So I'm really pumped about this. And I think that the amicus brief that we did and the win that we got in the Supreme Court will really go a long way for the legal center's ability to, do what we're doing a little bit easier.
Great. And I think on that note too, we currently see sort of a distortion of the idea of religious liberty by conservative and Christian right groups. And this issue came up at the Supreme Court again in Fulton versus City of Philadelphia. And we saw there, them trying to use religious exemptions in the case of adoption. So can you explain that, what we know from the ruling and what your thoughts are about it?
Yeah, so I see, we've got a lot of folks on this call or the Zoom, and it's a little bit hard talking about legal issues, and especially when a case is as anticipated as Fulton. I kind of have an expectation. Some people have heard of it. I'm sure some people haven't. I don't want to give a lot of background on all the facts and stuff as much as just to give you the takeaways and what's important for the legal center. But this Fulton decision was one where we were all on pins and needles, because at the heart of this case was whether the government, whether religious adoption agencies basically can have an exemption to, I'm abstracting this a little bit, but to discriminate against same-sex couples and otherwise couples that can, that are not straight couples. I'm sorry, I'm like garbling this, but the takeaway is that what was on the chopping block before the Supreme Court wasn't just another expansion, another exemption, but the opponents in that case were trying to get the Supreme Court to overrule the Smith test, which is the sort of cardinal rule of separation of church and state. The idea that just because, it's not the cardinal rule of it, but it's this very fundamental principle that just because you're religious doesn't mean you get to evade neutral laws of general applicability, like homicide laws and, traffic laws. Like, my religion says I get to drive in the left lane. Even if that's true, we say, sorry, the law says you have to drive in the right lane despite your religion. That's basically kind of what the Smith test is if there's a neutral law of general applicability, it's presumptively constitutional, the law is, regardless of if it burdens your religion. So the opponents of religious freedom, I would call them opponents of religious freedom. They would say they're fighting for it, but we're trying to get the Supreme Court to do away with that rule and let them for across the board. And the court didn't do that. They kept the Smith test intact, but they basically ended up siding with the Catholic adoption agencies and just made it, the exemption and the ability for religious groups to claim discrimination when they're really seeking a privilege. It's another marker on that belt, but we at least saved the test for another day.
Great. And that brings us, of course, to our litigation in-house. So can you talk about our active cases? And you might even mention how one of the Supreme Court cases has a direct tie to our current litigation.
Sure. So I mentioned this probably last year, but really since Trump has been in office or was in office, we really did have to re-strategize and be much more intentional and thoughtful. Not to say we've never been intentional and thoughtful with our cases, but really forward thinking. Because after the Supreme Court took one of our cases, I have to look at every case as, do I want this in front of this Supreme Court? And this Supreme Court is a lot different than the Supreme Court I started my career with when we had Obama in office. So now, and now knowing also that these cases can take 8 years. I filed the Greenville case almost right out of law school. And, so we've got several cases I'm really excited about, one of which we filed since the last annual conference. And it's one, so what I'm looking for now are cases where we can push the envelope and set ourselves up for the best position possible for when the courts are a little bit more favorable, but that's not to say there's not areas where we can not keep winning and also still be moving the needle forward. And so the case that we filed this year that we're really excited about is against, not that we're excited about it, I wish none of these violations happened and I could just go teach preschoolers art. But insofar as the governments are violating the Establishment Clause, I'm happy that we caught this one and that we're going to hopefully bring it to justice. Oklahoma, a big public school in Oklahoma, Marietta Public Schools, has for decades, as far as we're concerned, had a class called Missionaries during the school hours as a regular course. I think it was maybe once every couple of weeks. It's like in place of swim, and it's on their little calendar. And this is K through 8, so little preschooler kids were forced at this public school to take a class called Missionaries. And in this class called Missionaries, you have local pastors that come in, several of them, go into the auditorium. All the kids are in there. The teachers, the principals are by the door, and they sing songs about Jesus. They have this game where they pass a beach ball to the kids, and the kid that picks the beach ball has to answer a question about God or Jesus. And if you're an atheist kid like our client's child and you're 5 and you don't know anything about Jesus, it's a little intimidating when all your classmates are rattling off facts they learned in Sunday school. So we, when this came to our desk, I was looking at the facts and I was like, this just doesn't seem right. There's no way this could have gone on this long. A class called Missionaries. I mean, school prayers by students, student-led prayer at a public school football game was decided unconstitutional by the Supreme Court in 2000, despite it being student-led and short. This is a school class where missionaries come in and talk about Jesus in a public school. So I kept like, are you sure it's not a charter school, private? And like, no. So just to be double sure, we sent a FOIA request for documents because we were kind of like, maybe this 5-year-old is confused. I don't know. I really didn't think so, but I just I didn't want to believe this was true. And so we did a FOIA request to ask for documents pertaining to this missionary program. And immediately, so we didn't say we were suing, we didn't say anything. We got a letter back saying, oh, the missionary program, yeah, we're going to cancel that. Yeah, don't worry, nothing to see here. So they knew it was wrong the second they got any correspondence from Washington, D.C. So knowing that the program was canceled, this is a nice segue into what I was talking about earlier with that Supreme Court case and damages. is knowing the program's stopped. We can't seek an injunction to say, court, please stop it. They've done that already. But our clients and their child, this child was subjected to like 15 of these courses without the parents' permission. They did not know that their kid was going to missionaries. What if they were Jewish or another religion? This would be like blasphemous to take a child and convert them to Christianity in the public school system. Luckily, they're atheists, so it's, I don't want to say luckily, but it's like religious people don't always think about like, well, what if that was me and this school was teaching my kid something so against our religion that it's like blasphemous, or I don't know. The bottom line is this is so egregious. The parents go to the school, say, hey, we would really appreciate it if our kid cannot do this. And also, by the way, isn't it unconstitutional? They said, I guess your kid maybe can opt out. And yet, even after they complained, let them know it was unconstitutional, they still forced the family's kid to go to missionaries during school hours. So anyways, the long and the short of it is we're not just bringing nominal damages for $1, we're also bringing punitive damages to send a message that, punitive damages against the officials in their personal capacities, to send a message that the Establishment Clause needs to be followed. There really aren't that many. There's maybe 1 or 2 cases involving damages outside of nominal damages and outside of the prison context where a separation of church and state violation has warranted punitive damages. But I think should we win, this will be a historic victory, and one that hopefully, again, will add some teeth to separation of church and state. Because I think if there's any case where, the purpose of punitive damages, unlike compensatory, is punitive. It's to send a message. And we've got school officials that were so aware that what they were doing was wrong that the second a lawyer sent them an email or any sort of message, they stopped it. So anyways, I do think I'm excited about it because it's an area in which we can push a needle, and that is through the remedy aspect of it. So it's in the early stages. Any other questions about that one, Izzy?
Well, I think we have a few more people that have joined us since the top of the hour. And I think to people that maybe aren't in this field, it might be worth just expanding on the definition of nominal damages, just because I feel like sometimes we throw out these words, but it doesn't necessarily mean anything to the average person. So before you compared it to like symbolic damages, but would you want to explain maybe a little bit more?
Yeah, so nominal, I think there's a quote by O'Connor in one of these cases, might not be O'Connor, but it was, nominal, just because it says nominal does not mean nominal damages are trivial. It depends on kind of the case. Nominal damages come out of the common law and were originally used kind of in small claims, maybe disputes over property, sometimes in a contract case where there's no damages. There are cases where nominal damages, the dollar really does just mean like a very small victory. But in the constitutional realm, the Supreme Court and the lower courts have always seen nominal damages as a given, the idea that there has to be a remedy for the violation of your constitutional rights. So it's usually $1, might be $5. I mean, it doesn't, the money amount is, the point is that the money amount isn't really the point. It's that there has to be, just from a legal technical standpoint, the court can't just say you win. It's kind of like a legal fiction, but we don't treat it as that. We frame our dollars. We've got.
I was just going to say, yeah, we had a fantastic victory just a couple of years ago in our Carroll County legislative case. And in the DC office, as Monica was talking about, we have a dollar bill framed. Each of the plaintiffs received their $1. And then, of course, we received attorney's fees, which goes towards AHA programming. But that was just a fantastic, like, here we have a symbolic victory. We're going to frame it because it's important, the work that we're doing to protect the Establishment Clause. And we have, little moments like that where we can put it up on the wall.
I think we have a whole collection of them. I might have gotten lazy towards the end, but I know I have like our first $1 award that we won, because it means we won the case. So this Oklahoma case, we're definitely, I'm cautiously optimistic that this will move the needle. I don't want to get ahead of myself here because the courts are just so stacked against us, but this seems like an area that, again, transcends the Establishment Clause law to say what level of government action rises to the level of punitive being more than, nominal, and not compensatory, meaning it's replenishing you for something that was lost. Because again, we're not talking about economic damages cases. The other case we've had going on for a while that got a little bit slowed down during the pandemic, but is no less active, is our case against Arkansas for the Ten Commandments monument, which was quite high profile when it was going on. If some of you guys recall, there was 2 iterations of this Arkansas state capitol Ten Commandments monument. The first one had gone rammed into by a fellow. And so then they rebuilt it. We are bringing that case with Freedom from Religion Foundation and the ACLU and local Arkansas citizens that are members of AHA. And we are challenging this Ten Commandments monument as being new. So it's not, we filed this before the Bladensburg Cross case, but we're confident that because it's a very new monument and it was erected for a very clear religious purpose, evidenced by all of the testimony we have, I think we have a good shot. And this is a case where we have a lot of manpower on it, or I should say women and manpower, people power behind it. So yeah, so it's going to be a harder one because it's a monument case, and those have always been a little bit harder, but it's one that's definitely worth taking. I mentioned earlier our Ocala Police prayer vigil case, and that's a very active one. In fact, I've been working around the clock on the brief that's due in about a month, but I frame things in weeks because a month sounds like a lot of time. But when I look at a calendar and how many working weekdays I have, / obviously work on the weekends for this stuff. But so we have a case in the 11th Circuit now. So we defeated that nominal damage issue. And now we're squarely in the 11th Circuit surrounding the merits of our case, which is whether the government, the Florida Ocala Police Department, as well as the city of Ocala, violated the Establishment Clause by organizing, sponsoring, and leading and participating in a community-wide prayer vigil in which they had uniformed officers on stage with citizens, advocating for fervent prayer, giving Christian prayers, singing Christian songs, and posting all this stuff on their official Ocala Police Department letterhead and Facebook page. So we won this case in the district court. Luckily, the Florida U.S. District Court said this police prayer vigil it violates the Establishment Clause very obviously. Prayer is a religious activity, and police departments have no business organizing community prayer vigils. And there was way more to it. The issue now on appeal is they're trying to argue that the legislative prayer exception, that really narrow exception for opening legislative sessions with ecumenical and supposedly messages that are intended to unite lawmakers in their shared whatever. I'm trying to recite some of the language that justified this exception in the Marsh versus Chambers case. Most of us on this church-state separation side would agree that legislative prayer itself violates the Establishment Clause, but we have to sort of accept and live with the fact that it's legal. There's a big stretch and difference between prayer before opening sessions of Congress or local government meetings and a police department organizing a prayer vigil. One had the sanction of our founders who had paid chaplains to do legislative prayers. Now we also have all sorts of evidence that they later denounced this and said it violates the Establishment Clause. The justices ignored this, but the bottom line is that it's black and white. And there's very big difference between what went on in our case and what they're trying to say is legal. And it's unfortunately going to be a tough fight because, again, I'm in that circuit that I don't want to be in, the very conservative one. So this brief is going to take a lot of finessing and making sure that I save, that I only make our best arguments, because at this point we don't have the ability to, we have to be creative and we have to figure out a way to reach conservative justices, or at least aim for very narrow losses rather than broad losses. So there's just a lot more strategy and a different level of strategy that goes into these cases than what would have gone into it 5 years ago.
Yeah, and speaking of strategy, I'm wondering if you can kind of talk about the current makeup of the Supreme Court and maybe some other cases, both this term and ones that we know have been accepted for next term, that would be of interest to our viewers today, specifically the Brnovich versus Democratic National Committee voting rights case. I'll have you start off with that.
Sure. So this past term, I think I alluded at the beginning of the talk to the fact that we sort of dodged some bullets, but this is in large part, let's rewind a little bit between what happened last year and now. We have a different makeup of the Supreme Court. We lost Ruth Bader Ginsburg, and she has been replaced with a Trump-appointed justice. The reality that we have now is a 6-3 Supreme Court kind of baked in. You've got 6 very conservative justices and 3 justices that are not considered part of the conservative bloc. So even though there was a 6-3, we ended up not seeing all the cases this past term divided that way, in part because we had newer justices that were just getting their feet wet, figuring out how they align themselves. For instance, when Kavanaugh first was on the bench, he, I think, aligned himself a little bit with Kagan, but then after his first term, he was way more with Gorsuch and the conservative bloc. So what we can expect to see now that Amy's gotten her feet wet in this first term is, and they don't, now that they've got a 6-3, they don't have to be as narrow. They don't have to get each other to agree, because they can ultimately play around with, they can disagree with each other because they're still going to get the outcome that they want. So it's a little hard to explain that nuance, but it's a very scary reality that we're faced with in this next term, not only because of the makeup, but the cases that they've taken. We know they've taken a case on reproductive rights, and one that essentially puts Roe versus Wade on the chopping block. We know they've taken a gun rights case. And we just closed out this term, not only with the Fulton case, but with a voting rights case that really left intact, again, kind of like Fulton, left intact the test that's been used for voting rights cases, but narrowed it in such a kind of a sort of distorted factual way. And this was a Justice Alito decision. So you just know it's going to not be that good and principled, to be honest. And it wasn't. And so this voting, can you say the name of the case again? Izzy, I'm blanking on the name.
Brnovich versus Democratic National Committee.
Yeah. So what it came down to was there was a discrepancy in how the restrictions played out for minorities, but they basically said it wasn't enough. And so we don't even know what that quantity is, but even though the evidence showed that there was a disproportionate burden on minorities, they just said it doesn't matter. It's not big enough. So, and Alito had other things to say in that decision where he really curbed and tried to narrow the ability to bring these challenges, in the future. And the takeaway for us, we will certainly sign amicus briefs of groups that are working on these issues. It's obviously just not efficient for us to do these cases directly, because there's other wonderful groups that are. But as it pertains to us, these cases are important, both because they represent where the Supreme Court is right now and where it's going. We've got these 6-3 split, and we've got now they're sort of setting the stage to start probably knocking things down. There's very hard to think anything other than very pessimistically about, the reproductive rights case that the Supreme Court's going to take. It's just, I don't know. It's hard to feel, I'm trying to get the vibe from other people. It's possible they don't completely do away with Roe versus Wade, but what we're seeing is that they'll preserve a test, but then make it so difficult that it's almost like, what's the point of the test or the standard when all this other stuff is in place?
Right. And just to go off of that, I think one of the things, both looking at the Brnovich case and the fact that the Supreme Court has now accepted the Dobbs case to be considered next fall, or this upcoming fall, I should say, it's concerning too, just because, the Supreme Court now has more leeway to, decide something that could have a massive impact on a woman's right to choose or on voting rights. And Congress has several different bills concerning voting rights that are being considered. So, we'll hear from Rachel, our legislative director tomorrow. And, it's really, really important. And one of the wonderful things about AHA is that we hit progressive issues on all sides. So what we're striving for, both legally, we can also work towards with lobbying and encouraging congressional action to make sure that we're protecting voting rights and make sure that we're protecting a woman's right to choose. So with that, Nicole, I think we'll go ahead and take questions now.
I'm going to start with one from Sophia Lopez, who asks, when the average person observes a violation, what steps do you recommend to enforce separation of church and state?
Oh my gosh, I just love this question. I'm sure Izzy does too, because we have a whole process and it involves any way you can contact us. Like, people, honestly, if you witness something, first of all, if you don't have a picture, if you can't take a picture, if you can't record it, if you haven't, then write down as many facts as you can, just right when it happens, because sometimes these little details are useful for us that you don't think of. If it was like a monument or something that's recurring, like a morning prayer, if you can somehow get a recording or anything else, that's great. But just reach out to us right away. My email is mmiller@americanhumanist.org. Our legal, I think it's just legal@americanhumanist.org.
So our complaint form you can find online at humanistlegalcenter.org, and that'll prompt you to give us your contact information, to give us kind of a summary of the violation. And then, like Monica was saying, something that's hugely helpful to us when we're doing intake is just having as many facts and documentation as possible. And even if that just means a screenshot, it's really helpful to us, because if we do pursue action on it, then we're able to use those screenshots in a FOIA request or in a letter to school officials or city county officials.
And our staff has put the URL for that link in the chat, if anybody is interested. Randy Best from the American Ethical Union asks, can you talk about the AHA's work to have humanist groups recognized in prisons?
Yes. Hi, Randy. We are actually, that was the one case I forgot to mention. So we've been really successful in this area of getting humanism recognized. Starting off with, our first case was actually in the federal prison system. And so I won that case. It was in the Oregon, U.S. District Court of Oregon, but it was against the Federal Bureau of Prisons. And that case ended with the Federal Bureau of Prisons, all the federal prisons in the country now have to recognize humanism and offer humanist group meetings. And that was back in 2014 or 15, we had that victory. So I've taken that victory, and now we've gone into the other states. So we've now won in North Carolina. North Carolina has to recognize humanism. We won a case in Wyoming, although the case itself didn't win because we lost on mootness. The prison ended up recognizing it. Same with Nevada. Department of Corrections now recognizes it. We only take these cases when a humanist has been denied the ability to form a meeting. So it's not like we're choosing these states for any particular reason. It's where they're humanist inmates saying, we want to form a meeting, and they're saying, no, you can't, because whatever, for discriminatory reasons. And they usually are allowing all sorts of groups to meet, like Odinis and Druids and Rastafarians. There's groups religions that I hadn't even heard of, and they're telling humanists they can't have Darwin Day or, meet and talk about science and whatever. So we've been really successful in the case that we're about to bring. Maybe I'm not going to say where, but we're about to bring another humanist prisoner case. We've been working on it because of COVID. A lot of the prisons stopped having group meetings. But when we bring these humanist cases, it's important to remember we're never arguing that humanism is a religion. We are agnostic on that front. And if you ask me personally, I'd say it's not really a religion at all. But as far as the way the First Amendment treats religion and non-religion, the Establishment Clause requires the government to be neutral with respect to religion. And as the Supreme Court says, non-religion. So even if atheism is a non-religion, it still needs to be put on the same platform as religion. So when atheists want to form an atheist group meeting in prison, they are legally allowed to, even though they're atheists. So humanist is just the same. So yeah, we've had great success with those, and it's a perfect area. It's actually one of the few areas I would argue is kind of unfazed by Trump's judges, because these cases aren't like removing prayer from school or removing a cross from government land. We're just asking to be part of the mix, part of the fold. So we do win those cases, and honestly, we win them on really the cases themselves are good because the judges underscore and talk about and condemn the government discriminating against humanists. We had a really conservative judge in North Carolina, one that I talked to my friends at ACLU, and they said, this judge never rules in favor of civil rights. Good luck, kid. And we won. And you know, he saw what the government was doing. They were making our client go through all these additional steps and making up stuff, and like, oh, humanism doesn't have like a building here in North Carolina. Well, no, the Druids don't even have a building. They've recreated themselves in the prison system. So anyways, long and the short of it is, yes, we are continuing those cases, and we'll be bringing another one soon.
Curtis Rochette asks, all the issues you mentioned have been problems in Utah all my life. How come I never hear about cases being brought here?
Oh, interesting. You know, we haven't had we haven't had a complaint come out of Utah that's risen to the level of a lawsuit, but that's not to say it hasn't been. There was a case out of Utah involving crosses on the Utah Highway Patrol. Like, I think they were like around on one of the freeways anyways. And the 10th Circuit did find those crosses unconstitutional. It was Davenport or Duncan case. So there's cases in Utah. We was going
to say recently, Monica, you wrote a letter to a school district about a student being discriminated against because of what she was wearing. And that happens to be in Utah. Yeah. I
was going to mention that exactly. Yes. Yeah. So what there was an interesting one with Mormonism. And I think a lot of this is because the Mormon government the government in Utah, the Mormon government, that's sort of a Freudian slip, but they, in some ways, Utahns understand and appreciate separation of church and state more so than in the Bible Belt, because they've got more of a recent history with being actually like persecuted. And there's plenty of Christians that don't see them as Mormons as Christians. So they're kind of left out of the fold sometimes. But what we encountered actually was a, situation where there was a dress code that like 1-for-1 aligned with the Mormon like dress code. It was like, you know, they have special underwear and stuff, and like you couldn't have your shoulders out, and there were just things that you wouldn't see in like a California public school dress code. And so this young girl, like 6 years old, during the heat of Utah summer, was wearing like a dress that she was really excited about, like had a rainbow. I mean, this is a tiny child. And they told her shoulders were distracting and like made her go put on like a big t-shirt, and it was like humiliating. And so the father came to us, and like we saw this almost like not even just a church state issue. Like it was it's like a women, it's just, you can't do that to a child. I don't know. The whole thing was just, so we ended up getting the school to apologize to the kid, and they fixed it. But yeah, so we've had some issues in Utah, but just we see more in the Bible Belt. But we've also had we had a really successful case in Colorado, which is right next to Utah, and in the same circuit court against the Douglas County School District. And so the precedent that we established in the 10th Circuit case, that was the Colorado case, directly impacts Utah.
Okay, this one sounds like it comes from a lawyer, and you might have to explain some terms, Monica, before you can answer. Lydia Robbins Hendricks asked, yeah. Do you think there's any chance of avoiding a full-blown accommodation theory of the First Amendment under the current Supreme Court? And is Chief John Roberts more cautious in accepting this position than the others? I for one don't know what accommodation theory is. So
Lydia's in law school. I know her. She's awesome. So the question is kind of like, is the Supreme Court going to just, if I understand it correctly, I mean, are we just going to keep seeing them taking the side of religious rights groups and saying everything, this is just a religious accommodation, allowing them to discriminate against, allowing churches, government contracted adoption agencies to discriminate against the laws that we have in place? That they're saying that's an accommodation, we're saying it's a privilege. So she's asking, are we going to sort of see a transformation, and is it all just going to be this sort of accommodation land rather than separation of church and state land? And also, what is Roberts, the Supreme Court, even though Roberts is probably more Kavanaugh, Roberts is kind of looking more in the middle ideological spectrum, but that doesn't mean he's in the middle. The Supreme Court is so far over here that, to answer, the long and the short of it is, yes, we should be expecting to see a swing into more exemptions, more, privileges for religion under the guise of accommodation. And Roberts is, at least gives the aura of caring about the reputation of the Supreme Court and not having it look like a politicalized machine that is at the whim of a president. But now that we have a different president, I think Roberts was trying to say, I'm not going to be bullied by Trump or let Trump decide things. But now that Trump is gone, I don't think he has that concern as much. So I don't know. I don't have a lot of optimism with the Supreme Court. What I have is hope we can find some workarounds, either through legislation, through state courts, through bringing these cases where we push the needle or the envelope in a other direction, but not with the church-state parts as much. Yeah, it's hard to answer that and give something positive.
Yeah. In California, some public which is where Monica is actually, some public charter schools are holding their school days and staff developments in local churches. Students and teachers that complain about the locations and visible religious symbols are shut down or shut out. Ooh. This has been brought to the attention of the Charter Management Board and State Superintendent, and the practice continues. Is there anything that can be done? This is from Tabia Lee. And I guess there's also a question there about how charter schools relate to the First Amendment protections that public schools have to follow.
Gosh, these are wonderful questions. So this one actually is worth exploring. So I would encourage you, and maybe we'll just independently look at it, but if the questioner's listening, could you send us this information? Because charter schools, generally speaking, are subject to the exact same restrictions under the Establishment Clause as other schools. There's some states that might not be the case, and they might really be treated like private schools. But in California, I believe that there's no constitutional difference in their treatment. There are cases saying, we won a case, so I mentioned the Colorado case that we won against. One of the schools we won against was a charter school, and they were promoting this thing called Operation Christmas Child. But we also won cases where religious venues were used, like the Greenville School District case I mentioned at the beginning of this. One of the issues that we won on was that they were using a religious venue. It wasn't like a really decked out church. It was a chapel that was used in a university. So it really wasn't like a cathedral, but there was enough Jesus little icons for the court to say that making public school students pass through, these arches with crosses and stained glass windows with Jesus, it's coercive. It's not just like the effect is endorsing religion. You're coercing these students by meditating on these, Christian icons. So sometimes there's a few cases where like a school flooded and they, quickly they needed to use another venue, one-off thing. But if the intention is to continue these relationships and using religious venues for public school aims, whether they're charter or otherwise, there's no reason for me to say that I think that is unconstitutional. And California also has a state constitution with, I want to say, three sort of separation of church and state provisions, one of which doesn't even have a home in the Establishment Clause. It's the no aid clause, and it's very specific about not giving money to like churches. So yeah, let's look into this one. I'm curious about the justifications. Yeah.
Great. Alan Herman asks, do you accept cases arising in the military services?
Yes, we do. We've one of the first things that I worked on, we didn't end up having to take it to court because we won out of court, but was changing the Air Force enlistment form. We had an officer enlistee in Colorado, I think, an Air Force enlistee who was told he had to say, "So help me God" on his form, or else he couldn't enlist. And then it brought to light the fact that the form didn't have the opt-out part. So anyways, we ended up getting Congress, we ended up getting the Air Force to change its form so that atheists could easily opt out. We've had other cases. Well, our Bladensburg Cross case involved a military, a war memorial. And so we actually worked really closely with military groups, including the Jewish war veterans, obviously the secular, MRFF and MAAF. Yeah. So, but there's no category, there's no group of people for whom we don't bring these cases. I think bringing a case against the U.S. government is there's always going to be more challenges, but we've done it and we've succeeded. That, the case I brought against the Federal Bureau of Prisons won that case. So, yeah.
Okay, and I think we have time for one more. This may be kind of a big one. Do you think, this is Matthew Alicia, do you think Mississippi's challenge to Roe v. Wade in the Supreme Court will succeed?
So I might jump in here and just say that one of the big concerning things is that this is the first reproductive rights case that Amy Coney Barrett is sitting on the court for. The other big thing is that this now considers whether abortions anytime before 15 weeks would be constitutional. And, the current standard is not putting an undue burden on patients seeking access to abortion. But the issue is that, we know that there are lots of religious rights groups and these justices as well that are looking to try to eat away at Roe v. Wade as much as possible. So I think from where we're standing, and Monica, feel free to, chime in as well. Like, I think we're all kind of waiting on bated breath to see what's going to happen. But we'll be, ready to do what we can as a progressive organization to keep fighting for access to choose.
Yeah, what I would add is this, that I would hope the Supreme Court takes into account the consequences. From what I understand with polling, the consensus among Americans is generally that they're in favor of women's right to abortion up to a certain point, right? And so if the Supreme Court takes it away from that point where a lot of just average Americans that go up to my parents and ask them, just people that are not that political would generally be like, no, a woman should be able to choose. If that gets ripped out, you're going to have the pendulum is going to swing probably in favor of another Democratic election. So the Supreme Court, if there is an agenda to be had and they want to, change the tide and make things harder for progressives, they might find themselves looking at another progressive term if they rule this way, because we know it does not take a genius to realize this court is the direct product of a president. So we now have to just continue to remind citizens that voting matters, the president matters, and who the president picks in the Supreme Court and all of the lower federal courts matters. And the aftermath, we feel very demoralized right now, the lawyers that fight these cases across the board, not just church-state separation, but all of these issues. We've had some group calls lately, and it's just the sentiment is exhaustion, but we will keep fighting. But it does take everyone to vote and continue to keep helping other people vote and reminding them elections have consequences, reminding them that this Roe versus Wade business is a direct consequence of Trump being in office. So for people that didn't vote this time, it's just so imperative. And that's what I'd say about that. I don't have optimism about it. The only thing that makes me think that it would be cabined by anything is the Supreme Court's desire to not have another Democrat president.
Well, that's all the time we have. So I think that was an important last thought, Monica. Thank you very much. And thank you to Izzy for helping lead the discussion. We appreciate both of you joining us. You should watch for Monica's Legal Tuesday live streams every other Tuesday on AHA's social media streams. She'll keep you up to date on these issues and answer your First Amendment questions. So definitely tune in there. And you can also find past Legal Tuesdays on the AHA YouTube page.